The abolition of Section 21 under the Renters' Rights Act 2025 marks the culmination of many years of campaigning, consultation, and reform efforts across successive governments. This change has been discussed, delayed, revisited, and refined over a long period of time, and it has now reached implementation. This is not a minor adjustment. It represents a fundamental shift in how private landlords can regain possession of their property, moving away from a no-fault route and into a system where possession must be justified, evidenced, and assessed on its merits. In this video, I will not be going through notices or technical grounds in detail. Instead, I'm focusing on what this shift means in practice, particularly how evidence, proportionality, and individual circumstances now play a central role in possession outcomes. This is about understanding the new landscape and how operating within it will fundamentally change for the private rented sector. For landlords, this represents a seismic shift in how possession cases are approached, and it's important to understand what that means in practice. Section 21, also known as no-fault evictions, landlords were not required to provide a reason or consider vulnerability, mental capacity, language barriers, or support needs. They were not usually relevant to whether possession could proceed. That has changed. Once Section 21 is abolished from the 1st of May 2026 under the Renters' Rights Act, landlords will need to rely on Section 8 notices, which tenants can defend in court by challenging whether the legal grounds for possession are actually met and provide details of their circumstances that may determine the outcome of the possession claim, unlike Section 21, which allowed possession without that scrutiny. Section 8. Possession claims are defendable, and this is where the Equality Act 2010 becomes significant. What has perhaps been less openly discussed is Section 8 notices being defendable. Much of the focus has been on the fact that Section 8 has always existed and that it supports a fairer and more secure form of tenure for tenants. However, in the context of court proceedings, defendability has real and practical consequences. Unlike Section 21, a Section 8 claim requires the landlord to prove the grounds relied upon. In those circumstances, possession claims can become complex, lengthy, and costly. Where tenants have additional vulnerabilities, for example, a young family, children known to social services, or reliance on benefits, the court is often required to consider a wider range of factors before reaching a decision. This can include proportionality, equality considerations, and whether adjournments or further inquiries are necessary. While this does not prevent landlords from seeking possession where it is justified, it does mean that proceedings can carry significant financial and procedural risk, particularly where discretionary grounds are relied upon and mitigating circumstances are raised. Defences may cite, for example, the tenant did not seek professional advice, letters were not responded to due to mental or physical impairment, the tenant has known vulnerabilities or support needs. These issues can amount to protected characteristics under the Equality Act 2010 and trigger further investigation. When these issues are raised, courts may adjourn proceedings, request further evidence, seek medical or support reports, or explore whether reasonable steps were taken before litigation. This can significantly extend cases, and that matters, because time is money. Registered providers often have in-house legal teams, support workers, and dedicated budgets. Private landlords do not. Yet in practice, landlords may now be expected to demonstrate similar standards of engagement, particularly where vulnerability is known or apparent. By way of example, consider a working mother with 2 school-aged children living in a privately rented property. She has a history of mental ill health, but her condition is stable, she is in work, and she is paying her rent. A change in circumstances then occurs. One of her children is excluded from school, her working hours become unsustainable, and she loses her job. During this period, her mental health deteriorates and rent arrears begin to accrue. Prior to the Renters' Rights Act and the abolition of Section 21, this would likely have been a straightforward case. A Section 21 notice could be served and possession would follow, regardless of the wider circumstances. That is no longer the position. When the case comes before the court, the tenant seeks independent advice and her mental health history, alongside the presence of dependent children, becomes relevant. Issues of vulnerability, support needs, and appropriate signposting to money and welfare advice are raised. The focus is no longer solely on arrears, but on evidence, circumstances, and proportionality. What might once have been an automatic outcome now becomes a case that may be adjourned to allow support to be put in place. This simplified scenario illustrates how quickly ordinary life events can trigger a chain of consequences, and why, in an evidence-based system, early engagement and awareness can significantly affect how a case progresses. Possession proceedings have always been evidence-based and capable of being defended. This is not new for the courts or for housing practitioners. What is new is the practical impact on private landlords as the sector moves away from no-fault possession. In rent arrears cases, landlords may rely on grounds 8, 10, or 11 under Section 8 of the Housing Act 1988. Ground 8 is mandatory, but only if strict arrears thresholds are met at the date of the hearing and the notice has been correctly served. If those thresholds are not met, possession cannot be granted under that ground. Where landlords rely on discretionary grounds, such as ground 10 or ground 11, the court must assess the evidence, the tenant's circumstances, and whether it is reasonable and proportionate to grant possession. In those cases, hearings are often adjourned to allow tenants time to engage with support, reduce arrears, or agree a temporary arrangement to pay current rent plus an amount toward the arrears. The real shift for the private rented sector is that possession is no longer procedural or automatic. Outcomes now turn on timing, thresholds, and the quality of evidence presented. That has clear implications for time, cost, and the level of expertise required to pursue possession. What this scenario shows is that possession is no longer a straightforward, procedural exercise. In an evidence-based and defendable system, cases are considered on their individual facts, and outcomes are not fixed at the outset. Evidence may be incomplete, circumstances may still be evolving, and courts may adjourn proceedings to allow further information to be gathered or support to be put in place. The case may return to court more than once, with decisions shaped by what evidence is available at each stage. This is why Section 8 cases are not automatic, why they can be defended, and why possession is now determined on a case-by-case basis, rather than by a single notice alone. And this isn't limited to rent arrears. The same evidence-based approach applies in less obvious cases as well. A further example of how possession can become complex is a case involving ongoing disturbance at a private rented property. Neighbours report regular late-night noise linked to alcohol use. Complaints are made over a period of time, written warnings are issued, and the police attend on several occasions. There are no arrests, but cautions are given, and the behaviour continues to affect those living nearby. In the absence of a Section 21 route, a private landlord seeking possession in these circumstances may rely on Ground 14, which relates to antisocial behaviour. However, even where the conduct is serious, this is not an automatic or straightforward process. Without a conviction or mandatory trigger, the case turns on evidence. That often means gathering detailed records of complaints, retaining copies of warnings, and liaising with agencies such as the police or the local authority's antisocial behaviour team. The court will then assess the evidence, the persistence and impact of the behaviour, and whether possession is reasonable and proportionate. This type of case highlights how, without Section 21, landlords are required to engage in case preparation and multi-agency working, rather than relying on a single notice or procedural shortcut. These are exactly the kinds of situations that registered providers deal with routinely. Through specialist neighbourhood teams, clear internal procedures, and direct access to legal and support services. Private landlords are now navigating those same realities without that infrastructure and without a no-fault route to rely on. That often means gathering detailed records of complaints, retaining copies of warnings, and liaising with agencies such as the police or the local authority's anti-social behaviour team. The court will then assess the evidence, the persistence and impact of the behaviour, and whether possession is reasonable and proportionate. This type of case highlights how, without Section 21, landlords are required to engage in case preparation and multi-agency working, rather than relying on a single notice or procedural shortcut. These examples aren't fictional scenarios. They're drawn from real situations that can have a very real impact on people renting privately. These are exactly the kinds of situations that registered providers deal with routinely. Through specialist neighbourhood teams, clear internal procedures, and direct access to legal and support services. Private landlords are now navigating those same realities without that infrastructure and without a no-fault route to rely on. In many professional discussions and industry forums, there is a strong emphasis on the fact that possession grounds have always existed and can be relied upon where appropriate. That framing is technically correct, but it often stops short of exploring how those situations unfold in practice. What is less frequently examined is the process that follows once those grounds are relied upon, including the time involved, the potential for adjournments, the need for evidence to be developed over time, and the cost of obtaining professional support. For private landlords and managing agents who have not previously navigated these types of cases, the practical and operational impact is not always fully reflected in the wider conversation. In some cases, the court may explore whether the tenant had the capacity to properly engage with the notice and the process, taking into account factors such as language, literacy, or any apparent health-related issues. Were issues explained clearly? Was the tenant signposted to support? Were reasonable steps taken before court? These questions rarely arose under Section 21. Under Section 8, they increasingly do. Much of the public discussion around eviction reform has not been nuanced in relation to possession proceedings. Regaining possession is no longer quick, automatic, or purely procedural. It is contextual, evidence-based, and fact-sensitive. The aim of these reforms is greater fairness and security. But they also require a shift in how possession is approached in the private rented sector. Understanding these realities early helps both landlords and tenants avoid costly, prolonged disputes. So the key takeaway here is this: possession proceedings have always been evidence-based and defendable. What's changed is that private landlords are now fully operating within that system, without a no-fault route. Section 8 isn't just about serving a notice. It's about evidence, proportionality, and how individual circumstances can shape outcomes, sometimes in ways that aren't straightforward or predictable. This isn't about technicalities. It's about understanding the reality of how the system now operates and the time, cost, and preparation that can be involved. These changes also sit alongside existing pressures within the court system, including waiting times, administrative demands, and the way possession cases are now being managed. When that's combined with an evidence-based process, potential adjournments, and the need for professional input, it can affect how long cases take to resolve and the level of time, cost, and preparation required from private landlords. Thank you for watching Tenancy Talk.